Now, it's AM 650's The Law Show, a comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Well, good morning and welcome to The Law Show on this Remembrance Day weekend in Vancouver. A pleasure to have you with us. In studio from Lindsay Kenney LLP, we welcome back partner Angela Thiel and attorney Christine Eilers. Hello, Christine and Angela.
Hello again.
Hi, Sterling.
Nice to see you. And we're going to talk today about methods for resolving family law disputes. But before we get to the meat and potatoes of the conversation, tell us a little bit about Lindsay Kenney. Angela, we'll start with you as the senior in this duo today. Tell us a little bit about the firm, how long it's been around, and how long you've been practicing in Vancouver.
The firm has been around a good long time. It's got an office in downtown Vancouver and an office in Langley. I think we've been around 35 years or so. Yeah. I've been with it 24 years, been a lawyer 30 years. It's a general practice firm. That is, it has conveyancing and solicitors work, and it has general litigation. Christine and I both work in the family law area, although we both do other types of work. I do a lot of employment work and estate litigation, and Christine has been picking up some other parts of my practice as well as other work that other people in the firm give her. Mm-hmm. So we're a soup to nuts law firm.
But you specialize, Christine, along with Angela, in family law more specifically than any of the other areas of practice.
That's right. That's the bulk of my practice.
And how long have you been with Lindsay Kenney?
I have been with Lindsay Kenney for about 3.5 years now.
And now Angela was just saying you're expanding your activities or your sphere of activities to include other areas. Mm-hmm. But is family law what you're most drawn to?
It is. Yep. From the beginning, it was what I was most interested in. So it has made up the majority of my practice.
Now, we're going to talk today about methods for resolving family law disputes. And Angela, these methods don't always necessarily include lawyers, do they?
That's correct. I mean, a lot of people can't afford lawyers. So sometimes people will come to you for just an hour of advice.
Right.
Here are my circumstances. What do I need to do? Sometimes they'll have looked at some online resources, maybe have gone to the library, but they've read a lot and now they're really confused.
Okay. Mm-hmm. I was just going to say sometimes self-educating, particularly with the internet, can be, a dangerous road to travel.
Well, particularly right now because, of course, things on the internet don't necessarily get updated. Mm-hmm. And we have a brand new statute. So as of March this year, you've got a completely different way of dividing assets.
Right.
And so you can't just sort of go, well, it's my house and, we've had it 5 years because it may not necessarily be half and half. I mean, I actually got a phone call from a lawyer the other day who'd read the case that Christine and I just recently did, which is the first case in the Family Law Act. And he goes, well, yeah, but my client's on title for 50-50. I mean, does it matter that he put most of the money in? Like, yes, and this act is 2 years plus old. We've known about it since 2011, but we've still only got one property division case out, which is one Christine and I've got, and a few other cases on mobility rights, for example, a fair amount of cases. It's really changing the law. So to look at the internet, if you don't get the right site, you're not going to get the right information.
Right. Mm-hmm. So this act was proclaimed in March of this year. So this is really quite new, Christine. So it's very possible. In fact, it's more likely than not that a lot of these law.com type sites simply have not updated their British Columbia material.
Mm-hmm. A lot of them don't even have British Columbia material. I mean, you see people coming in who have read something from Colorado and think they're all up to date on the law because they were just reading a website on general divorce. But that's true. I mean, there's a lot of information out there on the new Family Law Act.
Right.
A lot of lawyers have been blogging about it or writing articles about it, but it's hard to sort of make sense of it all without actually speaking to somebody, I think, for a layperson.
Now, because, Angela, we're talking about methods for resolving family law disputes, do some of these methods refer to or are reflective of the new Family Law Act in BC? Has that new law changed the way business gets done between people who are, not getting along too well?
Oh, absolutely. The new act allows arbitration to resolve disputes. Now, with the same framework of judicial deference to what the arbitrator did, never had that before. That's in the new act. Parenting coordinators who were used before are now specifically referred to in the new act. The court can impose one on families that need one, as opposed to before it had to be voluntary.
Okay.
And so, mediation, which was always there, is given a stronger focus, and you now have an ability to mandatorily in a piece of litigation say, no, you have to come to mediation with me before we go into a trial.
Oh, I see.
So, things that weren't being, maybe were being done by people that said, well, let's try this, done voluntarily, now can be required of people. And arbitrators, I think, is going to be a great new thing for people that are looking for a way to resolve things that they can do in a fashion that is more user-friendly.
Okay, well, let's go down the list of the methods, because we're talking about resolving family law disputes. Christine, Angela's already talked about mediation and arbitration. What's the difference between the two?
Well, mediation, you are in a room with a mediator who's a neutral third party, and they're assisting you to resolve the dispute. They might give you some information and sort of make some suggestions, but at the same time, they're really looking at what are the two parties' interests and trying to help them come up with a solution.
We're familiar with this practice from labor law, where unions and management will get together at the bargaining table with the assistance of a mediator. So certainly in BC, we're familiar with that process.
And also in that context, arbitration as well, which is what's new to family law. And it looks similar, but ultimately that person, that neutral third party, is a decision maker, like a judge.
Okay.
So they can impose a decision.
A mediator can't impose a decision. An arbitrator can.
Correct.
And are you the two parties who agreed to go to arbitration in the first place, therefore bound by whatever that decision turns out to be?
That's how it works. Yes.
Okay.
To the extent of the normal rules, that if the arbitrator just goes way off base,
right,
you can not so much appeal, but you can administratively go to the court and say, I think this fellow was wrong. But it's a lot harder test. So you've chosen this method. If you don't like it, you have a limited review. But the great thing about the arbitrators is that they don't work, 10 to 4 with courthouse breaks. You can go to an arbitrator for a dispute, after hours in his office. You can make it user friendly.
Okay.
And plus, the arbitrators, the people that are suggesting themselves as arbitrators in our family law community, they know a lot about family law. I'm going to put in a plug for a colleague of mine, Larry Kahn. He just sent me he's a local lawyer in Richmond. He just sent me I'm going to be putting myself out as an arbitrator. This is a fellow that's been practicing in this area for, well, if I've been 30 years, probably 40. And in terms of financial issues where we have these unique ways we have to calculate things and unique things that we have to deal with that the average judge doesn't see, I would pick him in a heartbeat over the average judge.
Interesting. Okay. A veteran of the wars, so to speak. Who better to sit in between the warring parties than someone who's been there a lot?
And to make the decision, with all of the family law expertise that he's bringing to the table.
Exactly. Right.
Our judges are good, but you got to remember that they're appointed from a bunch of different areas of law. And they may not have experience in things like tax and, the sort of idea that, if I write all these things off on my income tax return, that's not the income that you use for guidelines for child support and spousal support purposes. So that type of analysis that we as family lawyers are used to doing, but isn't necessarily what a judge is trained to do.
Just as a complete aside, do judges who try divorce and family law disputes also work in other areas, or do you become a specialist at family law and only hear those sorts of cases? How does that work? How do judges have that workload distributed among themselves then?
Unfortunately, I think in British Columbia we do not have a family law bench. They do in certain other provinces. They have a family court division.
Right.
Where judges who say, this is what I want to do, at least for a period of time, and I want to specialize in this, I'm going to do this. In BC, it's just random. And, I mean, we honestly, as lawyers, don't know whether in the back rooms of the courthouse, there's sort of a list of judges who say, look, I would like to take this type of case, or I would like to take that type of case. As far as we can tell, it's relatively random. Notwithstanding that, some people who, have never practiced family law and they're, before they get on the bench, become some of the best family law judges. It's just an interesting sort of mix. And the judges, I think, find the family law cases the most difficult in terms of they get an awful lot of self-represented parties.
Oh, of course, of course. Well, now that's something I frankly didn't know, that in British Columbia we don't have a family law bench. We don't have judges who are dedicated specifically to hearing those kinds of cases. Now, we've talked about arbitration and mediation. What other methods are there at play these days for resolving family disputes?
Well, I guess one of the things that you touched on when you mentioned, not everybody needs a lawyer, is that some people just work it out themselves.
Okay.
Depending on how difficult the issues are to work through, sometimes at the end of a relationship, people will sit around the kitchen table and say, this is what we have, this is what we need to divide and figure out, and these are the kids, and this is what we want to do with them, and they'll come up with a plan themselves. Usually that's not the end of the road. There'll either be a dispute or they need to go to a lawyer to get legal advice on the agreement and have it put into a proper legal document. But some people just work it out themselves, or they use mediation on their own, or which is probably wiser. But there's also packages that you can buy sort of at the bookstore to help you finalize your separation agreement.
Do it yourself?
Do it yourself, yeah. Or online. I think there's resources like that available online.
Now, I've had lawyers on the law show here talking about those kits for wills and other things.
Yeah.
And they say, yes, they're legal.
Yeah.
But boy, oh boy, you really have to pay attention to all the fine print and get every detail they ask of you identified, or it's not legal. Or you lose because you left something out.
Absolutely. Yeah. Without advice, I mean, it's not a wise.
Well, what's really common is the kitchen table agreement, and then all of a sudden, the bank, someone's going to buy, someone's going to sell, buy them out. The bank goes, well, you need a proper separation agreement. And invariably, the bank has said that, or the mortgage broker has said that, like 3 days before a property transaction is going to close. So husband and wife sit together, say, well, look, I can afford to buy you out of this place, this house. Let's go over here and look at a condominium. We'll buy that for you. But it's all requires the bank to assist. And banks pretty well always require a separation agreement, and they usually want something a little better than what's on
something you bought at the drugstore.
Yeah.
Right. Well, you can't buy property in Vancouver for much less than $500,000 anywhere. So of course they're going to be a little serious about where that money is anchored, right?
Well, and the problem is what the worst thing is sometimes they've kind of come to that conclusion on the house, but they haven't really decided all the rest of the assets.
Right.
So people end up putting themselves under pressure, and they'll come in and they'll say, well, I need this agreement because we're supposed to buy this house for me, and yet we haven't resolved some of the other issues. So, and that's when you get these dangerous settlements where it's like, just put it on paper for me.
Right.
We try to say no. I mean, it's hard because, a decent client comes in and they need your help, but you're exposing yourself to incredible liability to say, well,
and
let's
client.
And the client, but it's more, they want a rush job and they're telling you this is okay. And I'm just dealing with one this week where it was the same type of thing. Well, I just went to any lawyer and signed and now I'm thinking I didn't get enough support, and probably not. So, but it's a lot harder to set it aside once it's done than do it right in the first place.
You had a funny story that you told Christine and me just before we turned the mics on this morning, Angela. You talked about a former client of yours who called you up out of the blue one afternoon and said, I'm getting remarried. By the way, I am divorced, aren't I? And you said, no, you're not. Yeah. And because once the separation agreement and all of the mechanics of executing that properly go through, a lot of people, just assume that, well, that's the end of that, and don't bother finalizing things.
Well, you got to remember that to be divorced, you've got to be separated 1 year.
Right.
And you've got to issue something in court. But they spend so much attention on the separation agreement that they forget the part about, well, the reason you're not yet divorced is because you finished this and you'd only been separated 5 months.
Aha.
Now, my normal practice is to say, as soon as we got the deal done, let's issue the divorce pleading, because you can serve it on someone, and then that part's done. They can say everything's fine, and then 6 months later they can actually file it in court.
Oh, so you don't have to wait until the end of the 12-month period.
No, you can issue the pleading
right there. To get the paperwork
right
started.
Right. But a lot of people have just gone through a relatively expensive process. They say, you know what, I'll take care of that later. And then they do. They honestly forget. And the other thing is advising people, change the beneficiaries on your RRSPs, your life insurance, your union pension plan.
Right.
I told you I did some estate litigation. That comes up all the time. And, I have a standard letter or email saying, now let me just remind you, have you done a new will? Have you changed these beneficiaries on all of these things? Because the fact that you're separated or even divorced doesn't automatically cause those things to happen. So that's the part that that is sort of another piece of litigation to come.
The story just cracked me up.
Yeah.
I mean, how on earth could you possibly not remember you're either divorced or not? I mean, kind of a traumatic moment in a person's life, I would think. But people get busy.
But think about it, Sterling. You probably, if you ever got divorced in the days you actually had to sit in the courtroom and give evidence, and there was a judge up there. Well, now it's go to the lawyer's office and swear an affidavit.
Oh.
And you sign so much paperwork during the course of a matrimonial
so there's
proceeding.
no formal appearance anymore.
There's no appearance.
No.
You don't remember it because you're not in court. The other thing that happens is that a lot of times people will say, and I always find this very funny, the wife will say, he left me, he can pay for the divorce. And so,
as though he's going to pay your fees, even if you're the wife's lawyer.
No, not at all. It's
Okay.
you started this. You wanted to leave me for somebody else.
So you finish it.
You finish it.
And you pay for it.
And one of the things that happens is that when you issue a court proceeding, one person may ask for the divorce. The other person is supposed to respond with a court proceeding, and they ask for a divorce too. But sometimes that part doesn't happen. The second person thinks, oh, well, she'll take care of it. And then, and I'm talking years later, I've got one years later where someone says, well, did I ever ask for a divorce? And I'm looking at the court pleadings. The precedent's changed about 3 times. And I'm going, no, you never asked for one.
Uh-oh.
So now you have to start all over again. As I was telling you before, one of our cases was a fellow who'd left it a long, long time, and a separation agreement itself is not completely legally binding. So there's still little wrinkles, and he just was in no hurry to get a divorce. And his wife came back, 10 years later or so, and wanted more money, and he
was a little vulnerable.
He was a little.
You want to get the
vulnerable.
divorce to start the limitation period.
That's
so it
right.
makes it more difficult.
Our guests in studio are from Lindsay Kenney LLP, online, by the way, at lklaw.ca. Angela Thiel and Christine Eilers are with us on The Law Show on this Remembrance Day weekend. Lots more ahead. Stay with us.
There's more of the show still ahead. This is AM 650's The Law Show.